This is American Government for Wednesday, September 22nd, which was yesterday, by the way. And again, as I explained, it was the Jewish holiday, and I just couldn't post a video by the time the holiday started on Monday night, which ended last night at sunset. So again, we don't have class tomorrow because of convocation, so the next time we'll meet will be Monday, and we'll be turning to, I sent out the revised schedules, you should take a look at that. And so Monday we'll meet in person, and we'll continue with, well, as I explained in my email, for the next 2 weeks, we'll be turning to the structure and content of the Constitution. Where we are in the courses right now is you've seen how the issues of the founding appeared with the Declaration of Independence and the Articles of Confederation, and then the failure of the Articles, and then the Constitutional Convention, and we've examined that and the theory of the Constitution, plus specific issues of race and slavery at the time of the Constitution. So our task now is to actually look at the Constitution and for you to become familiar with it. Now the Constitution, and as I said in the email, this is our only text for the next week. But nevertheless, there are quite a few PRQs on the Constitution. My aim is, consistent with the state law in South Carolina, is to make you as familiar with the text and the content of the Constitution as possible. And so over the next 3 sessions, starting with this session, what I'll do tonight is I'll take you through an overview of the preamble and the original 7 articles of the Constitution. If you're looking at the notes for tonight, for today I should say, I do this in 2 parts. One, I have a preface as to how to identify what a part or a clause or a text of the Constitution is doing. And I'll walk you through the 5 different ways of classifying a text, a clause, an article, or a part of the Constitution with respect to its function. And then I go through an overview of Articles 1, 2, 3 very briefly, and then walk you through Articles 4, 5, 6, and 7. And moreover, one of the most important things about today's talk is the relationship between the preamble and the articles. Now, as I say on the PRQs that I sent out, almost all the PRQs are findable within the text of the Constitution. You just have to dig hard in the Constitution, and that's part of your task right now, is to get to know the Constitution better by answering the questions. Some of the questions, which I do say, by the way, are not easily findable on the surface of the Constitution, and that's what I'll address in both the comments today and on Monday. But as again, most of the questions are answerable just by an attentive and very close attention to the text of the Constitution. So after walking through the other parts of the Constitution, you'll notice on the last page of today's notes is a summary chart, a chartograph, so to speak, of an overview of the 7 articles of the original Constitution and the preamble, which is a nice summary. On Monday, then, we'll turn from an overview of the Constitution, sort of like an overview of the map of the Constitution, which is what we'll discuss today, to a more specific internal examination of the structure of Articles 1, 2, and 3. Because Articles 1, 2, and 3 are really the articles that set up the new national government under the Constitution. So even though there's a good deal of borrowing between the old Articles of Confederation and the new Constitution, Articles 1, 2, and 3 are really quite new in that, again, as we saw in the Constitutional Convention, the Constitution scraps the Articles and replaces it with a new national government. And again, the implication of that change you'll see is in the nature of the preamble. Many of you probably had to remember the preamble in grade school or in high school or something, but and you might have learned that it was just like a rhetorical flourish to introduce the Constitution. Well, it does introduce the Constitution, but the preamble actually has important and critical information about the nature of the constitutional system, as we'll see. And so then on Wednesday, which is also a recorded lecture because the 4th major Jewish holiday begins this coming Monday night and goes till Wednesday night. And so I'll post a recorded lecture, as I'll let you know, on Monday. So if you're looking at the notes for today, some introductory reflections. What are the different parts, clauses of the Constitution doing? And I've created a classification of 5 different functions that a clause can do. Again, this can be a whole section, it can be a clause, it can be an article. So the first function that a clause or a section can do is it can be declarational. It can declare or state a fundamental principle or function or purpose. So, for example, the preamble is declarational in that it declares the source of authority of the Constitution, which is, of course, we, the people of the United States. And as you'll see, that becomes important, not the states. Remember, the source of authority for the Articles of Confederation was the sovereign states, who were the members of the Union. The name of the country was the United States of America. And again, the states were the sovereign members of the Union who could join it or leave it. But the Constitution creates a new union, not of the sovereign states. The states still exist, of course, but you'll see that they are somewhat demoted. They become not sovereign, or as they were in the Articles of Confederation, but semi-sovereign. They're not simply provinces of the national government, as in many other national systems, but nevertheless, the union now becomes the union of the American people, of individual Americans united as a nation. Hence, the opening line of the Constitution, "We the people," is not accidental. So part of the function of the preamble is to declare the source of authority. Then it goes on to declare the 6 specific purposes of the Constitution, which you can read in the preamble, of course. Example, the Section 1 of Articles 1, 2, and 3, those are called the vesting clause for reasons that we'll examine next Monday. They declare what state what the core function of that branch of government is. Article 1, Section 1 says, all legislative powers herein granted shall be vested in the Congress to consist of a House and Senate. Article 2, Section 1 says the executive power shall be vested in the President. Article 3, Section 1 says the judicial power shall be vested in one Supreme Court, etc. So the function of those of the first section of each one of Article 1, 2, and 3 is to state the purpose or function of that branch of government: legislative, executive, judicial. The opening clause of Article 6, for instance, declares the principle that all debts and agreements created under the old Articles of Confederation will be valid under the Constitution. So again, a declarational part or text states or declares a critical function or idea. The second function that a text can have is structural. That means it actually creates the structure or sets up the structure of an institution. And how does it do that? And again, here the analogy is like the building, like when you turn to an architect and have him design a building. Each room has a certain function or structure, and what the architect does is draw up a blueprint that shows you the structure of the building. In a way, that's what these structural clauses or components do. They create an institution with a structure. And mostly, when you're talking about setting up an institution, it involves mostly considerations of membership, who can be a member, the size and the number, the term, and who may vote for such members. Those are the structural considerations. So example, the vesting clauses of Article 1, 2, and 3, which were essentially declarational, as we said above a minute ago, also tell you some structural information about the respective institutions. So, for instance, Article 1, Section 1 says, all legislative powers herein granted shall be vested in the Congress to consist of a House and Senate. You already learned, in other words, as opposed to the Congress under the old Articles, which was unicameral, a one-chamber Congress, that Congress now is bicameral. It has 2 chambers, 2 houses, a House and a Senate. You learned some structural information in Article 2, Section 1. You learned that the President is a single individual, which we talked about from the Constitutional Convention. And in Article 3, Section 1, you learned that the judiciary is hierarchical. It says one Supreme Court and such inferior courts as Congress shall from time to time establish. So, again, the structural component actually creates or sets up institutions. Third, an article, a text, a clause, a section can be procedural. It sets up a way of operating or rules or procedures which have to be followed to produce a legitimate result. The most obvious one is an Article 1, Section 7, which contains the information as how a bill becomes a law. Again, it sets up a procedure. Article 5, for instance, is primarily procedural because it sets up the procedure for amending the Constitution. The fourth kind of function is what I call relational. It defines the proper relationship between an institution and other institutions. So, for instance, Article 4 sets up the relations between the states within the constitutional system. It puts certain obligations on the states, like returning criminals, as you'll see. And probably the most important relational clause in the Constitution is in Article 6, called the Supremacy Clause. It puts the various elements of American politics in relationship to each other in terms of authority. The Constitution is supreme, and then the laws and treaties of the national government come next, and then the laws and constitutions of the states. So what that part of the Constitution is doing is relating the different parts of the Constitution. The Constitution on top, it says, for instance, this Constitution and all laws of the United States in pursuance thereof and all treaties of the United States shall be the supreme law of the land, anything in any state law or constitution the contrary. So literally, the Supremacy Clause in Article 6 sets up a pyramid of authority. The Constitution at the top, and actually, by the way, from the Preamble, with the people above that, the Constitution deriving its authority from the people, and then the laws and treaties of the United States come next, and then the laws, Constitution, and actions of the states at the bottom. The last function that a clause or a section can do is limiting. It puts either positive duties or negative limits on what an institution can or cannot do. So, for instance, Article 1, Section 9 says what Congress cannot do. You'll see that Article 1, Section 8 says what Congress can do. It lists the specific powers of Congress, which we'll look at on Monday. But Article 1, Section 9 says what Congress can't do. Article 1, Section 10 says what the states cannot do. And so, for instance, I would say that if you look in Article 2, which is the executive article, Article 4 spells out the grounds for impeachment of the president, which, of course, puts a kind of a limit on the powers of the presidency. So with that in mind, on the second page of the notes, let's now turn to an overview. Now, my purpose here is to give you a sense of what the overall structure of the Constitution is and how it's laid out. The Constitution is may seem like a long document, but it's actually one of the shortest written constitutions in the world. And as we're going to see when we turn next Wednesday to the amendments, even though there are 27 amendments to the Constitution, it's been relatively rarely amended compared to many other state constitutions in the United States or many other national constitutions. Just by way of comparison, the Constitution of India, for instance, which I know something about because I visited India on a scholarly trip for 7 weeks in 1990, runs to over 239 and 40 pages long. The Constitution of the European Union is over 500 pages long. So the Constitution of the United States, depending on how large you print it, what font you print it in, is about 7 pages long, which is pretty short. So why is the Constitution of the United States so short and so concise? It's because it doesn't try to solve every issue in society as many other national and state constitutions do. So the framers kept, and this, by the way, goes back to the Golden Article that we looked at, why blacks, Jews, and women are not mentioned in the Constitution. The Constitution sets up a basic framework for government and channels power and sets procedure for how government should operate. It doesn't try to solve every social issue, and to some degree that accounts for its relative brevity, but also why it's been relatively it's been amended relatively few times. 27 is actually compared to other state constitutions in the United States and other national constitutions is relatively few. So starting now with the preamble, we'll start with the preamble, and then again, as I said, I'll look at Article 1, 2, and 3 together just for general purposes, and then turn to Article 4, 5, 6, and 7, and that will conclude our overview of the whole constitutional system. So I say that so if you're looking under Roman numeral 2, under the preamble I said is declarational and structural. And it would be good, of course, to have a copy of the Constitution with you. Now, it's declarational in that, as I already pointed out, it declares the Union to be, the American Union, no longer to be a national union of states. even though the name of the country remains the same, the United States of America. It shifts the basis of the Union away from sovereign states to individual Americans, in effect, for the first time defining the American people. Again, it's not that an American people didn't exist under the Articles of Confederation, but there was no institutional embodiment of that. It's like, if you look at the United Nations, what's represented in the United Nations as a confederation of nations is the nations of the world. We don't vote for our representative in the UN, and in some kind of notional sense, you could say that the people of the world are represented in the UN. But again, the UN is not a government of the world that unites the people of the world in one government. It's a confederation of sovereign nations, and that was the nature of the Articles of Confederation. The Preamble says that that nation is no longer in existence to some degree. So it not only creates a more perfect union, the point here is that the Constitution creates a different kind of union. And as you'll see, one of the PRQs asks you what other parts of the Constitution is the Preamble in particular related to, and although I don't always specifically answer the PRQs, I'll answer that one because it's not evident on the surface of the text of the Constitution. It's Article 7, and you'll see that what Article 7 does, which is the ratification procedure of the Constitution, it actually creates the American people. I should say, in ratifying the Constitution through the ratification procedure that we'll see when we turn to Article 7, the American people actually comes into being. So the entity that ratifies the Constitution through, as you'll see, the special mechanism of state ratifying conventions, that's the critical thing in Article 7. The American people, which the Preamble declares to be the source of authority of the Constitution, and that's why I say there's a structural component. You could say that the Preamble with Article 7 actually creates a new institution called the American people, from whom the Constitution directly derives its authority. Again, so the specific answer to that PRQ is Article 7, as you'll see when we come to Article 7. So the Preamble is primarily declarational. It declares the source of authority to be the American people, and it has the 6 purposes of the Constitution: a more perfect union, defense, general welfare, blessings of liberty, etc. But it also has a structural component in that, again, this new institution called the American people is coming into being and giving its authority to the Constitution. So that's the meaning of the Preamble. Articles 1, 2, and 3 are essentially structural. They create the new institutions of national government that the Constitutional Convention brought into being or created. Remember, under the Articles, there was no executive branch. There was no judicial branch on the national level. There was only a single unicameral Congress. Now, Articles 1, 2, and 3 create the Congress, the bicameral Congress under the Constitution, the presidency and executive branch, and the Supreme Court and the national judiciary, and to some degree the state legislatures. There's a reason why the Constitution begins with these 3 articles and why they are structural. Again, the country already existed, the United States of America. A Congress already existed. But the Constitution essentially wipes all of those, the old Confederation away, wipes away the old Congress, and replaces it with the 3 new institutions of national government. So, in a broad sense, they create the national government that governs the American people. And notice the Constitution, which is C, capital C in my notes, reverses the order of the Articles of Confederation respecting the states and the national government. Whereas the Articles of Confederation, if you remember, if you read the Articles, recognizes first the states, then turns to setting up Congress. The Constitution reverses that. After the Preamble, the first task of the Constitution is to set up the new institutions of national government. Hence Articles 1, 2, and 3. Now, again, on Monday, we'll actually turn to the internal content and structure of Articles 1, 2, and 3. We'll devote the entire lecture on Monday to that purpose. So again, the way I've designed this discussion of the Constitution is again, from an overall view of all 7 articles and the Preamble, then on Monday to the internal content and structure of the new national institutions of national government, Articles 1, 2, and 3. And then on Wednesday, we'll consider the 27 amendments to the Constitution and how to group and understand those. So, again, even though there are declarational, procedural, relational, and limiting aspects to Articles 1, 2, and 3, they are predominantly structural. And as you'll see, those other qualities we'll examine on Monday. So Articles 1, 2, and 3 create the new national institutions of national government. Article 4 now turns to the relationship between the states. So I call Article 4 structural and relational. Why? Because, again, it doesn't create the states. The states already existed, and to some degree, when a state comes into the Union, it exists as a sovereign entity joining the Union, or the people of that state do. But you could say that it recreates the states, no longer as sovereign nations or sovereign entities composing the Union, but as semi-sovereign entities. The American people actually recreate, not only create the new institutions of national government in Article 1, 2, and 3, they also in some respects recreate. So the way I put it in the paragraph on the third page of our notes is, Article 4 doesn't create any new institutions, although it recreates the states, so much so that you could say that, like the Articles of Confederation Congress and the Constitution Congress, the states under the Articles of Confederation and the Constitution shared only their names. And you'll see our discussion of Article 7, which is key to the whole argument about the nature of the Union and the American people, as you'll see. So what are the sections of Article 4? And so, by the way, Article 4 is structural in that it kind of recreates the states, but it's mostly relational in that it says what the relations between the states within the constitutional system are. And as we'll see, those are the 4 sections of Article 4 actually spell that out. So, for instance, Article 4, Section 1, states have to recognize the laws and official acts of the other states, which I explained in class. That's why my driver's license in South Carolina is valid in North Carolina and all the other states of the Union. Article 4 says that the public acts and laws like marriages, divorces, driver's licenses, property titles, all those kinds of things that are official in one state have to be recognized by all the other states in the Union. And that's why Article 4 sets relations between the states. Article 2. Section 2, of Article. They have to grant citizens the fundamental rights of other states. That is to say, if I'm an official resident of South Carolina, but I own a house in North Carolina. In other words, Article 4, Section 2 says that the states basically have to treat the citizens of other states almost as they treat their own citizens. They have to extend to them the same fundamental rights of suing in court and property rights, etc. Section 2 goes on to say that it has to return criminals. So a criminal that flees from one state has to be returned to the state that he fled from or she fled from. And of course, Article 4, Section 2 also contains one of the 3 references to slavery, but doesn't have to mention it, the Fugitive Slave Clause, which says that people held to labor under the laws of one state fleeing to another state have to be returned to the individual to whom the laws of that state grant that service. Section 3 in Article 4 talks about how new states are admitted into the Union. And of course, the last states to be admitted into the Union were Alaska and Hawaii in the 1950s, which brought the total to 50. And then the last section guarantees a Republican form of government to each state and protects it against insurrection. So Article 4 is somewhat structural in that it recreates the states as semi-sovereign, but relational primarily because, again, as you've seen, it states the different relationship between the states, what the states have to do to and for each other and for the citizens of other states, and how new states come into the Union. Now, at this point, you have to see that after Articles 1 through 4, all the major components in the constitutional system now exist. The American people, through the Preamble, and as you'll see, Article 7, the national government and its institutions, Article 1, 2, and 3, and the states, Article 4. So after that, so if you think about it, the system is complete with respect to its components. So what would be the next logical subject that the Constitution would turn to? And that is how to change the system. And that is exactly what Article 5 turns to. It's essentially procedural in that it lays out the proper procedure for amending or changing the Constitution. Now, a couple of things to note about this. Remember, in the Articles, it was the state legislatures that had to unanimously had to approve all amendments, which is why the Articles of Confederation was never amendable, because it required unanimity. And again, once you require unanimity for any procedure, you almost doom it to impossibility. Now, it's clear, the Constitution, as you'll see in Article 5, wants to render the Constitution and the constitutional system changeable, but more difficult. In fact, in general, one of the PRQs asks you to list all the different kinds of majorities that are required. And you'll see, for instance, there is and essentially, by the way, let me just say this, you're talking about essentially 4 different kinds of majorities. A simple majority, which is 50% plus 1. And the Constitution says, for instance, in Article 1, that in order to have daily business and pass legislation, Congress requires a simple majority of the members of both houses. The next kind of majority is 2/3. And you'll see, wherever the Constitution wants to make a procedure possible, but more difficult in everyday business, it puts a supermajority on it. So, for instance, to expel a member in Article 1, Section 5, it requires a supermajority of 2/3 of the members of both houses to expel a member. To override a presidential veto in Article 1, Section 7 requires a 2/3 majority. To ratify treaties in Article 2, Section 2 requires a 2/3 majority of the Senate. In Articles 1 and 2, for conviction of impeachment, as we'll see, the House can impeach, that is to say, bring charges against a federal official with just a regular majority. And if you were paying attention during the 2 impeachments of President Trump, you know that it was a majority of members of the House, primarily along party lines, that the House voted to impeach. But to try and convict a member, an individual, it requires a 2/3 majority in the Senate. So it's easier to bring charges under the impeachment process than it is to convict. And as you'll see in the amendment procedure here in Article 5, 2/3, and that, by the way, the third majority is 3/4. And of course, 3/4 is even harder to attain than 2/3. So you'll see in the way to arrange Article 5 is that proposing an amendment requires 2/3 of what? We'll talk about that in a second, and requires 3/4 to ratify. So again, my point I'm making here is between making amendment impossible through unanimity and making amendment too easy through an everyday majority, the Constitution lets the constitutional system be amendable, but more difficult because it puts these supermajorities. So as long as we're on the subject, and I said the 4th majority, and you'll see in Article 7, it takes 9 of 13 state ratifying conventions. So the 4 kinds of majorities in the Constitution are a simple majority, a 2/3 majority, a 3/4 majority, and the 9 out of 13 states to ratify the Constitution. More about that later. So in Article 5, the amendment procedure that we're talking about, it takes 2/3 of what? 2/3 of the state legislatures. I'm sorry, let me go back to the beginning. 2/3 of both houses of Congress can propose an amendment. And note the president has no role here. He doesn't sign or participate in the amendment procedure. So 2/3 of the members of both houses of Congress can propose amendments. And indeed, all of the 27 amendments that have been passed under the Constitution have been proposed through 2/3 of both houses of Congress. The other procedure, which has never been used before, is when 2/3 of the states call for another convention. That method has never been activated, and no amendment has been produced by that way. On the other hand, to ratify puts the standard even higher with a 3/4 majority. So, indeed, there are 2 ways of ratifying an amendment, where 3/4 of the state legislatures can ratify an amendment, and all but 1 of the 27 amendments have been ratified that way. The other way to ratify an amendment is through 3/4 of state conventions called for that purpose, which somewhat imitates the original ratification method of the Constitution in Article 7. And only one amendment, the 21st Amendment, which repealed prohibition, was ratified in that way. So there you have the way to change the constitutional system. Now, I also say that it can be, you could say, and this is on the top of the fourth page of the notes, you could say that that Article 5 potentially creates a new institution, either a second constitutional convention if 2/3 of the states call one, or the state ratifying conventions or state legislatures in the ratifying procedure actually become like a super legislature. But Article 5 is primarily procedural, as I've said, because it states the procedural, lays out the procedure for changing the Constitution. Article 6 is a very busy article. Generally speaking, Article 6 is named for one of its clauses, the Supremacy Clause. It's called the Supremacy Article, but it's doing several things. It actually has declarational functions. It declares several critical principles. It has a relational function, a procedural, and a limiting function. First of all, in Article 6, it declares the old union and the new union to be a continuous thing in terms of debts, treaties, and engagements. It does that so that all the debts that we had encountered under the Articles of Confederation wouldn't be wiped away. Many times when there's a revolution in the country, the new government simply wipes away the debts of the old one, which of course damages the credit of the nation. So the framers actually made it clear that any debt or law or obligation under the Articles, or any treaty under the Articles, was to be considered just as valid as if it had been under the Constitution. The second function is relational, and I've already talked a little bit about that, but to repeat it now, it puts the elements of the constitutional system in proper relationship with supreme, the Constitution, and then subordinate to that, the laws of the government and the treaties of the United States, and subordinate to that, the states, the Constitution and laws of the states. So the Supremacy Clause creates a three-tiered system of authority. And again, remember, this was addressed to a problem under the old Articles with state compliance with the Articles themselves and with the laws of Congress. So the Constitution explicitly says that the Constitution is supreme. The laws of the national government, treaties of the national government are next, and at the bottom of the system are the laws and constitutions of the states. Now, it's also procedural in that it sets up a mechanism for enforcement. And just to remind you, under if you remember in the Constitutional Convention, the Virginia Plan, drafted by Madison and proposed by Governor Randolph of Virginia, called for the Congress to review and reject the laws of the states that it deemed unconstitutional or inconsistent with the national government. The Articles of Confederation called for the executive power to call out the military power of the national government against the states. Remember that complicated little mathematical formula that I suggested, that the Constitution now replaces legislative supervision of the states or executive supervision of the states with judicial review. And here it is in Article 6, the procedure. It says the state judges, and the federal judges for that matter, must declare void any state law or constitution that conflicts with the U.S. Constitution and or with the national government and national laws. So probably one of the most famous court cases that you are consistent with, or that you're familiar with, is Brown v. Board of Education in 1954, when the Supreme Court invalidated state segregated schools. In other words, any state that officially segregated its schools by law, or in some cases in state constitutions, the Supreme Court declared that that was inconsistent with the Equal Protection Clause of the 14th Amendment. When we talk about the amendments, we'll come back to that. So it's procedural in that it sets up a procedure for enforcing the superiority of the relational part of the Supremacy Clause. Also, by the way, it sets up a system of oaths. Every public official in the United States on every level of authority has to take an oath to support the Constitution of the United States. And the only oath that's actually specifically different from the general oath of support that every member of the national government, state government, county governments, municipal governments, every person that has public authority in the United States has to take an oath or I'll come back to the affirmation in a minute. But the president, of course, as we'll see when we turn to Article 2 on Monday, takes a unique oath. He takes an oath to execute his office faithfully and to preserve, protect, and defend the Constitution. The president has a unique oath. Now, the last function in Article 6 is limiting. It limits the ability of the U.S. to push a particular religion because it prohibits any religious tests for office, and by allowing for an oath or affirmation. And this does answer one of the PRQs. The difference between an oath and an affirmation is an oath is a religious swearing, a public religious swearing. Now, of course, most Christians would swear on the Bible, Jews would swear on the Torah, Muslims would swear on the Quran, and Hindus would swear on the Bhagavad Gita. But what the limit here is that a person may not be religious, might be an atheist, and what an affirmation is a secular swearing. So, for instance, all of the 46 presidents have taken an oath on the Bible. They've all been Christians. But if you had an atheist president, then the president would simply take an affirmation. And that's why both in the president's oath and in Article 6 it says oath or affirmation. And in Article 6 it goes further and says that no religious test shall ever be the basis of a qualification for office. So even before the First Amendment, which we tend to think of the Constitution's primary protection of religion, Article 6 already limits the national government in terms of imposing a religion on people who serve in it. Now, the last article of the Constitution, so by the way, that's why Article 6 has both a declarational component, it has a relational, a procedural, and a limiting component. Now, Article 7, which is the ratification article of the Constitution, if you look on the notes, I call it both procedural, structural, and relational. So it's procedural primarily because it lays out the procedure for the Constitution becoming official. As I said, at 9 out of 13 states, which I used to say is roughly 3/4, but to reiterate, remember, of the 4 kinds of majorities in the constitutional system, a simple majority, 50% plus 1, a 2/3 majority, a 3/4 majority, and the 9 of the 13 states here. So, remember, the articles were required that it be ratified by all 13 states. So, in some ways, remember, just like the amendment procedure in Article 5, Article 7 points to a ratification which is more difficult. It's not just a simple majority of the states, but it's 9 out of 13, which is a somewhat higher majority. So it's procedural, and then it says how. And then how does it say? It says, when 9 of the 13 states in ratifying conventions ratify the Constitution that will go into effect between those 9 states. And that's exactly what happened, by the way, when in 1788, when the ratification process was completed. Eventually, all the states, of course, joined the Union. But the critical thing to see here, to see the point about what Article 7 does, and its unique relationship to the Preamble, is the substitution of ratifying conventions for the state legislatures. The Articles required a unanimous ratification of the Articles by the state legislatures. Why? Because the states were the sovereign members of the Union. But the Constitution turns from the states and the state governments as the ratifying mechanism to state conventions. Now, if you think about it, just as we discussed in the class on the Constitutional Convention, when it came to the election of the president, there were 3 possible alternatives. To have Congress elect the president, to have the people elect the president directly, or to have a special body. And of course, that's what the Constitution eventually adopts in terms of the election of the president, the Electoral College. In some ways, you could say the same thing. And you could say this: if the Constitution truly did rest upon the direct authority of the American people, then it should have been by majority vote of the American people directly. The Constitution, in other words, and by the way, most state constitutions, in fact, all state constitutions are ratified by popular vote of the people of that state. So why didn't the framers opt out for a national referendum direct voting of the American people, since the preamble does rely upon we the people as the source of authority. The basic answer is that they thought that a national referendum was probably simply not physically or logistically possible. Remember, it took Washington almost 3 weeks to get from Mount Vernon to New York, which was our first capital to take the oath of office in 1789. And so but part of it was travel, part of it was, you have to remember how, in some ways, how primitive the conditions of travel and communication were. So the framers did not think that it was possible for the Constitution to actually undergo a vote of the entire American people. Such a thing had never been done before. And again, as we saw, they didn't want the state legislatures to be the ratifying institution, since that would seem to imply that the Confederation was still in effect. That is to say, that the state legislatures and the sovereign state governments were ratifying the Constitution. They wanted the authority, as the preamble says, to come from the American people. So they chose the third alternative of a special set of ratifying conventions. Now, to understand this, it's almost as you have to see that they saw the ratifying conventions as the people of that state, sort of embodied for a special purpose. And the way to explain it would be something like this. If in normal state government, like when you vote for a representative for the state government, they deal with all the different issues of government. And therefore, you can't say that, now you might be a single issue voter, by the way, and you might vote for a representative or a party because of one particular issue. But generally speaking, what the state governments deal with is the whole aspect of government, whether it's family law, criminal law, commercial law, etc. But the ratifying conventions, if you think about it, were like a special temporary legislature that only had one issue, and that is yes or no. So voting for a member of the state ratifying convention was a much more direct and explicit conveying of intention in your vote. So since the ratifying conventions only had one specific issue, Constitution up or Constitution down, the framers considered that was actually sampling popular authority directly, and that therefore, and so it might be better to imagine the ratification procedure this way. That when, and by the way, the first state to ratify the Constitution was in fact Delaware, and its ratifying convention approved the Constitution, and then was followed by Pennsylvania. If you understand what I'm trying to suggest here about who's ratifying the Constitution and what's really happening here, it's not so much that the state of Delaware ratified the Constitution, but rather the people of the state of Delaware ratified the Constitution. And when the people of Pennsylvania, through their ratifying convention, ratified the Constitution, it's not that the state of Delaware joined with the state of Pennsylvania in a confederation, which was the old basis of the Union. Rather, the people of Delaware joined with the people of Pennsylvania to form a new people called the American people. And when those two states ratified, the American people consisted of the people of those two states. Then, as the ratifying convention of each state ratified the Constitution, the people of that state joined the people of the previous states that had ratified. So, the people of each state by state joined the American people, so that when the Constitution was finally ratified, again, it wasn't 13 sovereign states that ratified the Constitution. It was the people organized into states that joined the people in ratifying the Constitution. So the reason that the preamble is directly dependent upon and related to Article 7 is the preamble says that the source of authority is we, the people of the United States, the American people. And what the ratification procedure does in Article 7, it creates that American people through the special ratifying procedures of the ratifying convention. So that literally, Article 7 is the article that creates the American people. So that's why the part of the Constitution that the preamble is most directly related to is Article 7. Because the procedure for ratifying the Constitution actually created the American people, state by state, as the people of each state joined the people of the United States to ratify the Constitution. So, and one would have to say that in general, the ratification of the Constitution was the most democratic and open procedure that had ever existed in the history of humanity. The Constitution was widely debated, in the churches and towns and inns and the public squares. The text of the Constitution was printed and published in newspapers throughout the Union and also directly. Many different institutions discussed it. Remember, the American people had the highest rate of literacy for reasons we talked about because of its Puritan origins and the Protestant Reformation, which required mass literacy. So, of all the systems of government in all the history of humanity, the Constitution of the United States was the first one truly to live up to the opening lines of the preamble, "We the people." It was the most open and democratic ratification procedure of any system of government in the history of humanity, where the people of the United States really did ratify and accept the Constitution and give their authority to it. So, there you have an overall view of the Constitution. And in the chartograph form at the end of the notes, it summarizes all of that. So there you have the preamble, which declares not just a more perfect union, but a new union of the American people as opposed to the old sovereign states. And by the way, here's a little bit of interesting information, that when the Confederate States met and seceded from the United States and formed their own constitution, they felt it necessary to put "we the people of the Confederate States" in the sovereign states assembled. In other words, they felt it necessary to reiterate explicitly the principle of confederation, which the Constitution actually abandons. So there you have it, the preamble, which states the source of authority to be the American people and therefore creates or speaks the American people into being, plus the 6 purposes of union, justice, domestic tranquility, defense, general welfare, and liberty, the 6 specific purposes of the Constitution. Article 1, which creates the legislative branch. Article 2, which creates the new national executive branch. Article 3, which creates the new judicial branch. Article 4, which sets the relationship between the newly recreated semi-sovereign states in order. Article 5, which tells you how to amend the system. Article 6, which puts the different parts in relational order. And Article 7, the procedure by which the system becomes official, and the procedure by which the American people spoken of in the preamble actually come into being. On Monday, again, we'll now turn to a more specific and internal examination of the internal content structure of Articles 1, 2, and 3. And then next Wednesday, in our recorded lecture for the last of the Jewish holidays, we will turn to the amendments of the constitutional system and how to understand them.